Morning, everyone. Welcome to this morning's In-House in Focus Brexit update. Now, we're going to be trying very hard in the next 45 minutes or so to distill down for you some key points for you to be considering in the run-up to the end of the Brexit transition period. And in case you need a reminder, that ends on the 31st of December this year. The topics we're going to be looking at today include a roundup of the status of the deal with the EU and some thoughts around trade between the EU and the UK. Then my colleague Mark Benton is going to be looking at immigration. Peter Wayman will then touch on data protection and some points for you to consider. And then Simon Pedley is going to round up by talking to you about some issues that you need to consider in the context of dispute resolution. Like I say, we're going to aim to keep our presentation to 45 minutes to allow 15 minutes at the end for Q&A. And if you do have questions, pop them in the Q&A box at the end, at the bottom of your screen. We will do our best to deal with as many of those as we can within the allotted hour. As with all our In-House in Focus webinars, this webinar will be recorded, and a link to the recording and the slides will be circulated in a few days' time. So I think you can expect to receive the link and the slides in the early part of next week. A final point is on feedback. Of course, we welcome your feedback. We're very keen to continue to improve and evolve our In-House in Focus programme. So once this webinar finishes, we end the webinar, there will be 4 feedback questions for you to complete, and we would be very, very grateful for your feedback and suggested topics you'd like to hear about in the future. So let's look first at the status of negotiations with the EU. I suspect everybody is aware that the negotiations between the UK and the EU teams are running right up to the wire. In the last week or so, there's been surprisingly little media coverage and press comment on the status of the negotiations, though the negotiating teams do tell us that they consider that they are 95% there. The main outstanding issues are around fishing rights, the level playing field and enforcement. The level playing field issues relate to things like competition law, state aid, workers' rights, environmental protections, and anti-dumping. So those are the level playing field issues. On fishing rights, the position as at last weekend was that the EU were proposing that we could retain 15 to 18% of fish caught in UK coastal waters. And needless to say, the UK government views that as unacceptable, and it seems that a large part of their argument around this is we are fundamentally an island nation and therefore should be allowed to keep a lot more of our fish. Finally, on enforcement, the outstanding issue is really how this deal is going to be enforced should there be disagreements. One thing is sure, though, is that if we do reach a deal, it will be a limited, what some people are calling bare bones deal, other people are calling a skinny deal. And there will therefore remain a large number of issues that continue to remain resolved. So we can expect further negotiations to continue for some time to come on those outstanding issues. I now want to turn to trade in goods as between Great Britain and the EU. And I'm focusing specifically on trading goods, and because of the sort of nuances around Northern Ireland, I'm looking at the Great Britain EU position. So that's England, Scotland and Wales. Turning first to imports. So 54% of what the UK imports comes from the EU. So naturally, a key concern of business is what happens at the end of the transition period and the extent of disruption that might be caused. What Great Britain will be doing is implementing what it is calling the border operating model. What this does is it phases in changes for the importers of goods over 3 stages. Those stages being rolled out January, April and July. And the idea behind that is to allow businesses a run-in to prepare themselves fully. So from the border operating model, from January, those importing standard goods will need to complete some basic customs formalities, and they will need to keep sufficient records of imported goods. There will need to be export declarations provided and safety and security declarations for all goods. If you are in a business which is using the Common Transit Convention, then that business needs to continue to follow those transit procedures, and those won't be introduced in stages. Then moving to April, all products that are of an animal origin or are plant products will need pre-notification and health documentation. And when I'm talking about products of animal origin, that includes things like honey, milk and eggs. And then from July, that's the final phase of the border operating model. We move to businesses moving any goods having to make full customs declarations at the point of importation and deal with tariffs and so on. Just turning to VAT, businesses that are importing goods from the EU need to consider how they account for and pay for VAT. VAT will be chargeable on imports from the EU at the same rates that are applied to the rest of the world. Now, there are going to be a number of schemes to defer payment of VAT for up to 6 months. The VAT still becomes due on import, but you're able to defer payment for up to 6 months. So it is worth, if this is relevant to you, having a look at those schemes. And just looking at tariffs, naturally there are going to be tariffs due on imports, and the UK government is implementing a new global tariff schedule, and that is the point of reference for determining the tariff due on an item that is imported. To be fair, the general consensus around this new UK general tariff is that the government has simplified, and therefore it's viewed as generally positive. So tariffs are simplified compared to what they were previously when we talk about the rest of the world. But this UK general tariff is going to apply to all markets where we don't have a preferential trade deal. So if we don't reach a trade deal of some sort with the EU, this tariff is going to apply to imports from the EU. Even if we do have a preferential deal in place, both with the EU and indeed other countries, you'll need to look at the terms of that preferential trade deal to work out the impact of it on tariffs. So now let's have a look at exporting. Let's flip the coin. And going back to the value of exports, so the EU is our single biggest export market. It accounts for 46% of UK exports, and that is worth around about, close on 290 billion. If we don't reach a deal with the EU, we will be treated as a third country by the EU, and tariffs will apply to pretty much all goods that we export to the EU. And the process for exporting to the EU is going to be fundamentally different. So from January, all goods that head to the EU are going to need export declarations. They're going to need safety and security declarations. And if you are dealing in controlled specialist goods, there may well be additional licenses and further processes and declarations that are needed. The EU will have full import control of goods arriving from the UK. So that means customs declarations, it means checks and inspections. If we don't reach a deal with the EU, then the goods we export are going to be subject to the EU tariff schedule. The tariff schedule is referred to, probably a bit ironically in these circumstances, as the EU MFN, Most Favoured Nation tariff schedule. But like I say, we are treated as a third country, and therefore the rates that apply to us will be the standard rates, the rates that the EU apply to anybody that they don't have a preferential trade deal with. So in a nutshell, what we can see in a no-deal scenario is that the combination of tariffs, customs procedures, regulatory change mean the burden on business is quite significant. And that is, of course, aside from the fact that if we've got a raft of customs checks going on at borders, you know, we can easily foresee that there can be delays at ports and consequent supply chain disruption. So, like I say, that's a very quick canter through of key issues around importing and exporting goods from the EU. I'll now hand over to Mark, who's going to talk to you about immigration.
Thank you, Jane, and good morning, everyone. So, yeah, I'm going to speak to you for a few moments about immigration. Obviously, the end of the Brexit transition period has massive implications from an immigration perspective, both in terms of the ending of free movement and also the implementation of new points-based visa routes. So I think what I'll do is I'll try and provide a bit of an overview for you, and then look at some key actions in a moment that can help smooth over this transition period. So the three key points I think to take note of are listed on the slide here, and the first is that the eligibility period under the EU settlement scheme is coming to an end. So I'm sure everyone's familiar with the EU settlement scheme at this point. In brief, it is the scheme that the government put in place to ensure that EU nationals who are already living in the UK can continue to do so beyond Brexit. The way that works in practice is that any EU national who is resident in the UK by the 31st of December 2020, i.e. by the end of the transition period, will be eligible under the EU settlement scheme. So they can apply for status and continue to live here for the rest of their lives if they so choose. So that's the first deadline to be aware of. The second deadline is that anyone who is eligible under the scheme must make an application by the 30th of June 2021. So in essence, there's a 6-month grace period whereby people who can apply need to do so. What that means also in practice is obviously EU nationals who don't qualify for the scheme, so who are not resident in the UK by the end of this month, will actually be caught by the new points-based system, which moves us on quite nicely to that second bullet point. We have actually already seen this system be implemented. So as of Tuesday this week, the new system went live. Obviously, this is within the context of Brexit. Brexit is the catalyst for this new system. But of course, as I've just said, at the moment, it only applies to non-EU migrants. As of the 1st of January next year, it will also apply to EU migrants because there will no longer be freedom of movement. This system has, of course, been heavily publicised, and it is going to be the key route for economic migration, and in this context, particularly important from the point of view of workers. So there are some practical implications around that, which I'm going to come onto on the next slide in terms of key actions that businesses can be taking now. The most important point really to be aware of in relation to the new system is that final point on the slide, which is this skilled worker visa category. So this is the main change, and this again is what has been heavily publicised in terms of our new points-based migration. By way of background, the route for actually permitting workers to come to the UK to apply their trade has previously been the Tier 2 general visa route. That route obviously no longer exists and has been replaced by the skilled worker route. The important thing to note about both of those routes is that they require sponsorship. So the business, the employer, must sponsor a migrant to actually enter the UK to work. Obviously, previously the main route to do that was through Tier 2. Now the main route to do that is through the skilled worker category. And of course, the underlying theme here is, well, this is going to apply to EU nationals. So what that means is, in practice, is there's going to be a massive increase in sponsorship of migrant workers by necessity. Previously, EU nationals did not require sponsorship. As of next year, they will. This new category builds on its predecessor, and in the context of an increase in usage, what we're seeing is actually that the category itself has become broader and easier to implement, I think is probably the best way of putting it. I've listed there a couple of the key differences, the benefits, if you will, of the skilled worker visa as opposed to its predecessor, the Tier 2 General. We don't have time to obviously go through all of those in depth, but essentially the message here is the requirements have been lowered across the board, and the procedure behind actually providing sponsorship and of bringing migrants to the UK has been simplified. In particular, those points at the bottom there: no resident labour market test, no cap on migration. In theory, that could actually speed up the process of recruiting migrant workers by about 2 months. So it's mostly good news, but obviously the flip side of that is, well, these are requirements that didn't apply at all to EU nationals previously. So the system is I think fit for purpose, but obviously nowhere near as beneficial as freedom of movement. So that's a bit of an overview, and now turning to the key actions that businesses can be taking in relation to actually these new points. So I've listed here for you what I think are the 6 most important actions to be taking now, if you've not done so already. The top action there in relation to sponsor licenses, I think is the most important. So as I've already said, bringing migrants over, non-EU and soon to be EU nationals as well, will require sponsorship. And so basically all employers are going to need a sponsor license. So if your business does not have a sponsor license, we would highly recommend that you actually obtain one as soon as possible. That's all done online with the Home Office. But for those who already have a sponsor license, it's worth reflecting on whether or not that license is still fit for purpose. So there are a few points to pick out here. If you are a licensed sponsor, you already have that set up with the Home Office. That will have been set up under the old system. Now, the Home Office updated all sponsor licenses on their end. So as of the beginning of this week, those licenses were essentially transferred from the old rules to the new rules, which means if you hold a sponsor license, that is still available to you. You can still make use of that. But given the increase in the requirement for sponsorship moving forward, it's worth checking that your license is actually up to date and reflective of your business. And I think this is really a key point, because it would be very easy to actually fail to meet your compliance duties as a license holder simply by virtue of not having correctly updated the license. So worth just going in, checking, is everything up to date in terms of the contact details, for example, the key people that are listed on the license, and also whether or not perhaps new offices have been opened since the license was first obtained. Just make sure everything is saying what you think it should be saying. So I think that's really the key point. These other issues are fairly self-explanatory. Recruitment timing is relevant for EU nationals, obviously, by virtue of the points I was making earlier in relation to deadlines. If you have EU nationals who are in the process of being recruited by HR, worth checking if they can come in before the 31st of December and therefore make use of the EU settlement scheme. Obviously, it's in their benefit to do so. It is also in the business's benefit, because you then don't have to provide sponsorship. Strategic planning and resources are just points around obviously being ready for these changes, notwithstanding that they've already happened. There are still things you can be doing in preparation for EU migrants. And in particular, what I'd stress again is, look, we're probably going to see a huge increase in the requirement to sponsor migrant workers. So are your HR teams ready to deal with that? Is upskilling going to be required? Are your policies actually saying what they need to say in relation to this new system? Okay, so just worth reviewing those sorts of things. In relation to existing EU staff, again, deadlines are relevant here, and I do think there's a value in pushing out communications to current staff members just in relation to those two deadlines I mentioned earlier, 31st of December for eligibility, 30th of June next year for actually making the application. And then the final point, just to round off everything I've been saying here, obviously this has been a bit of a whistle-stop tour in terms of what are quite complex changes to immigration law. It's worth noting that new guidance has been issued in relation to all the topics I've been speaking about here. And I would strongly recommend seeking out that guidance on the gov.uk website, because it's actually a lot more user-friendly than it used to be and does provide some good context to what I've been saying. So I'll leave it there and hand you over to Peter.
Thanks, Mark. So I've got a single slide to try and cover all the data protection issues that arise as a result of Brexit, and I'll try and do it in a 5-minute burst if I can. We'll see how we go. So I thought I'd start with the good news, which is broadly that the position is that data protection laws in the UK are not going to change a whole lot as a result of Brexit. So there are not a huge amount of compliance problems for UK businesses in terms of their day-to-day GDPR compliance. You don't have to go through another GDPR implementation type program like you would have done a few years back. So that's good, and it's also good that the mood music is that the likelihood is there'll be a lot of consistency between UK and EU laws on data protection for the foreseeable future, for the reasons I'll come on to in a moment. So again, in terms of multinationals doing business across the UK and EU, it's unlikely there'll need to be material differences between your approach in the UK and in the EU to your DP compliance. So that's the good bit. I mean, on the latter, the reason I said for now on the slide, that there are areas where we could see small changes. One example is in relation to the use of email marketing and electronic communications, where there's been a bit of draft legislation kicking around the EU for a long time. We're not quite sure where that's going to land, and it's one where the UK's position in terms of the lobbying on the approach to that has differed from some other parts of the EU. So who knows? He says totally speculating, but that may be an area where we see some minor differences in future. So that's the good bit. I did think about wondering whether I could categorise my three main bullet points as the good, the bad, and the ugly, or something like that. But it's more so that's the good. This is the ugly, I'm afraid. So transfers between the EU and UK is a bit of a muddle. Is probably the truth. So the ideal will be that the UK gets an adequacy decision, which is basically where you're allowed to transfer personal data from the EU to the country with the adequacy decision without really doing anything else. And so we've got that at the moment. For example, if you're transferring personal data to Canada or Argentina or Jersey, for example, there are a number of countries that have that sort of decisions. The ideal would be the UK gets one of those decisions. The tricky bit is we really don't know whether we're going to get an adequacy decision. And we also don't know when we're likely to get that adequacy decision. And in truth, there are some areas of concern in terms of there being the likelihood of there being an adequacy decision because of, for example, our UK laws on investigatory powers for our law enforcement and intelligence services. So that's just the sort of thing that's caused the EU concerns in terms of the US approach to personal data and data protection. So given that we've got some of the same issues here, it may be that there's a problem getting an adequacy decision, and certainly I've had discussions with colleagues from other European countries raising that as a concern in terms of the likely direction of travel. So certainly the answer is, from a practical point of view, we can't rely on that. So in the meantime, to make sure that where transfers from the EU to the UK are possible post-Brexit, that the only option we've got that's simple to implement is these standard contractual clauses, or model clauses, you may have heard them referred to. Unfortunately, whilst this is the obvious solution for most people, and so this is what people would typically put in place for intragroup transfers, for example, for HR databases that cross the rest of the EU with the UK, to sign those, to cover those transfers, and also for transfers between customers and suppliers, where, for example, if you're appointing a software as a service or hosting provider and it's cross-border, then you would commonly use these standard contractual clauses. Unfortunately, there are some limitations around those SCCs. So, for example, we don't have SCCs to cover every scenario. So we have what we call controller. So they're typically used for like the HR intragroup scenario that I mentioned earlier. We have controller processor. So if there's a controller in Germany transferring data to a processor in London, for example, we have a contract that could cover that. So you could future-proof by signing those now to cover a post-Brexit scenario. Unfortunately, what we don't have is processor to sub-processor. So, for example, if that German customer was transferring to a processor in Germany who was then transferring on to a hosting provider in London, we don't have a contract for that processor sub-processor arrangement, and we also don't have a contract to cover processor to controller transfers. So, and also the truth is we're using rather creaky, out-of-date standard contractual clauses that long predate the GDPR. So at the moment, people will probably be familiar with this, you're having to sign a data processing agreement and attach the standard contractual clauses to cover off both your GDPR obligations and the international transfer requirements. And on top of that, we've got the problem that you may have heard that there was a Schrems challenge to the use of the Privacy Shield in the US, which also called into question the use of standard contractual clauses without putting certain additional steps in place to ensure that the transfer provides an adequate level of protection. So our current group of approved contractual clauses are problematic. The good news is on that the EU has, or that the Commission has published some draft new clauses to cover all the scenarios that need covering and to bring them up to date for GDPR compliance. And there's a consultation on those that's due to end in December. The optimists would say they'll rush those through, get them approved, and we'll be able to start using them in time for January. In practice, at the moment, until they are approved, they are not technically a legitimate legal basis for making that transfer. So that unfortunately is a watch this space for January. So what we're seeing people typically do at the moment is to put in place, if they haven't already done it, standard contractual clauses to cover those EU-UK transfers where they can under the existing templates, with a view to then implementing the new ones if and when they come into force. And we have seen some rather convoluted drafting where people have tried to account for all scenarios ahead of time. So these are the ones that apply now, these ones that will apply if they're approved from January. The truth is, what we're seeing a lot of our clients do is watch this space. So we've got the European Data Protection Board running the consultation and looking at guidance around what's an appropriate way of managing those transfers. We've got the ICO watching this very closely and prepared to issue guidance on it. And the truth is, in terms of my question mark likelihood of enforcement from EU regulators, I think it's fair to say that most people don't expect those EU regulators to try and enforce against people who frankly have tried their best in terms of those transfers, but are having to kind of pick their way through a bit of a muddle at the moment. So I think the prudent thing to do is to, where you've got some standard contractual clauses to cover the transfer scenario you've got, use them. Where you haven't, be ready to put something appropriate in place as soon as it comes in. But to be honest, don't panic, because I think that the likelihood of any significant enforcement action until things have settled down is probably low. But definitely one to watch this space with. So that was it on the ugly of the international transfers. And the last bit, it's neither good nor bad nor ugly. It's just a bit sort of tediously administrative. So this is representatives in the EU and UK. So broadly, if you are in the UK and you're processing personal data relating to people in the EU, and you don't have an operation in the EU, you need to look at putting in place a representative arrangement in the EU, so that broadly the regulators there have somebody whose door to knock on if something goes wrong, and the flip side applies the other way around. So for EU people processing personal data about people in the UK, or people outside the EU and UK also processing data about people here. So we've had a number of questions coming from clients looking for help appointing representatives in the EU, and work with some of our partner law firms to help with that where we can. So that's definitely one to watch. So I think that's all I wanted to cover on my slide. Hopefully I'm just about on time, and I'll pass over to Simon at that point.
Thanks very much. To talk about some cross-border dispute resolution issues post-Brexit. Some are pure dispute resolution, choice of law and jurisdiction and how that impacts on enforcement and all the rest of it, and a few others just of sort of contractual areas where disputes may be rife. And as with everyone else, I imagine, one might have hoped that with only 4 weeks to go, we would know what the answer is going to be on a number of these things. But sadly, we don't know. So I'll just explain where some of the issues may arise. And this is of relevance to anyone who has any dealings with any party in EU countries, suppliers or agents or distributors, whatever it may be. You will have to think about this. So dealing first with choice of law, this is the one sort of bit of good news that for now at least Brexit shouldn't affect this too much. EU countries are currently bound by the Rome I Treaty, while the UK won't be bound by that after this year. It's been incorporated into UK law by separate regulations, so that choice of law regime will basically continue to apply, and basically that just says the parties can choose whichever law they want, and that choice of law will be honoured by the relevant courts. So even if you've got a mishmash between choice of law and a different jurisdiction or a non-exclusive jurisdiction clause, if both parties have chosen English law or have chosen French law, whichever court hears it, that law should still be enforced. Jurisdiction, however, is more complicated. And I suppose just a quick reminder, why is choice of jurisdiction important? Well, the main thing is if you've got a decent regime in the majority of cases and most types of contracts, not all, but it allows the parties to choose which courts should hear these things and deal with enforcement and the rest of it. It allows you to avoid some courts you may wish to avoid. And my wife works in-house, and her company's been dragged into some trademark proceedings in the Netherlands, which they're finding immensely frustrating procedurally and in all other respects, and it's not operating as that similar litigation would operate in England and Wales. And actually the English and Welsh courts and the Scottish as well, no doubt, operate on a pretty decent basis, which is why a lot of parties choose English jurisdiction and choice of law to regulate disputes. And so the current regime allows you to deal with this, and it allows you to choose jurisdictions to hear disputes which would be convenient for the parties and for their witnesses and for all those sorts of things. Broadly speaking, at the moment, under the Brussels recast regime, which governs these things, the parties can choose, subject to some exceptions around things like real estate or insolvency or whatever, but contractually you can choose whichever jurisdiction you want, and pretty much the courts will enforce that. So if someone tries to sort of sneak in ahead and start proceedings in say in Italy, when you've chosen English jurisdiction, the Italian court should put a stop to that, and the case should proceed in England. At the end of transition, at the end of this year, that regime ceases to apply. What the UK has done is applied to join the Lugano Convention as a separate contracting state. The Lugano Convention is similar to Brussels recast. It not quite so user-friendly or helpful, but if you've got an exclusive choice of jurisdiction clause, it operates in a similar way. And that convention applies to EU countries, EFTA countries, Switzerland, Iceland, and Norway. So we've applied to join that as a separate contracting party. The EU can veto that, and they haven't yet agreed to it. So we don't actually know whether we'll be joining the Lugano Convention or rejoining it as a separate entity. In fact, only last week, literally a week ago, a letter was sent, signed by a variety of organisations, including the law societies of all the jurisdictions in the UK, the City of London Corporation, the British Retail Consortium, the British Chamber of Commerce, and so on, to the EU's warning that a failure to agree this and agree our accession to the Lugano Convention would be bad news for everyone. It would result in various inconsistent national rules applying. It could put access to justice at risk on both sides of the English Channel. You could have two courts with jurisdiction or none with obvious jurisdiction. You'd need to have separate recourse to courts in different countries for enforcement, which might not be straightforward. And so this letter concludes and says, look, clearly allowing us to join the Lugano Convention is the solution. We've had letters of support from Norway, Iceland, and Switzerland, and they'll be happy for us to join it. But thus far, unless something has happened over the last 24 hours, which I've not seen, not the EU so far. As an aside, if any of you have dealings with Norway, we have in fact, woohoo, Sovereign UK has signed a separate side deal with Norway that we will have effectively the Lugano Convention just between the UK and Norway, if nothing else. So there are those with a strong Norwegian business interests will have some more certainty. If we don't join the Lugano Convention, then we'll have to rely on the Hague Convention, which we can just join anyway as of right. The EU can't block that. They are much less applicable. The contracting states at the moment are the EU member states, the UK, Mexico, Singapore, and Montenegro. It gives you some legal certainty with agreements if you've got an exclusive jurisdiction clause, and enables enforcement of judgments obtained thereby much more easily. But it doesn't apply to agreements with non-exclusive jurisdiction courts, and it doesn't apply extraterritorially anyway, but that's the situation at the moment anyway. So it's not really a satisfactory outcome. If you've got dealings with EU countries regularly, you want there to be a pretty certain regime. So for what you may be doing, well, it'll be very dependent on your particular business and organisation. I mean, there might be an impetus to choose a European jurisdiction if that's where the person you want to sue is and where their assets are. You may think it's better for you to choose, say, a French jurisdiction, even if the court process is less good for you, if that is your only effective route thereafter to getting redress should the contract not work. So it'll depend on whatever you've got. Quite a lot of clients are therefore looking at arbitration clauses as an alternative to choice of law and choice of jurisdiction clauses for court work. And arbitration is, of course, essentially a private contractual court process, generally confidential. The key benefit of that is that's governed by the New York Convention 1958. There are like 160 signatories to that convention. You'd be hard pressed to find anyone you're dealing with internationally who isn't a member of that. And that allows for the enforcement and recognition of arbitration awards in all the contracting estates. There's no similar regime for English court judgments. So, for instance, if you deal with America, say, it may be much easier to have an arbitration clause, because that's probably much easier to enforce in the States than an English judgment. But that's the situation anyway. You may find that that is better for dealing with EU countries, given the uncertainty with other things at the moment. There's all sorts of pros and cons for arbitration to bear in mind. And just finally, as an aside about enforcement, we talked about jurisdiction, where the party is based. What you're really interested in is where that party's assets are based, because a judgment is just a piece of paper. If you can't enforce it and get payment, it's a worthless piece of paper, maybe very expensive to obtain. So in all of this, you're thinking about not only the party you're dealing with, but actually how in practice you would enforce any judgment you get. So that's law, jurisdiction and enforcement. Just briefly then, territorial references to the EU. In any contract, the question is, if it says, for example, you've got a license or an agency agreement which says the relevant territory in which you can do X, Y, or Z is the EU, does that include the UK? Or certainly does that include the UK after the end of this year? It depends. If it, my view, and the firm's view, I think, is if you had a contract which defined territory as the EU before the end of January 2020, before we actually left the EU, then it's almost certain, I think someone would say, that's meant to include the UK, because we were still a member of the EU at that point. On a proper construction of the contract, that may not always be the case. There may be reasons for saying it wasn't meant to include the UK, but that would be a sensible starting point. After this year, from 1st of January 2021, you would have to assume that contract entered into then, which refers to the territory being the EU, that will not include the UK, because we absolutely won't be part of it then. And at the moment, when we're still in the transition period, when we're, in practical terms, we're behaving as if we're still in the EU, even though we're not, it will be a matter of sort of context and interpretation of the contract. So I think if you've got those sorts of contracts which define territory, it's worth your while, if you've not already, just reviewing those, just to check that those territorial definitions will work as you want after the end of this year, and maybe worth just some renegotiation or some some clarification or side letters or whatever, just to be clear on that. And on a similar vein, I guess, what about references to EU law? And a number of commercial agreements will contain references to EU law, and this may cause challenges again after the end of this year, because EU law will cease to apply directly post the end of 2020. Will references to EU law, therefore, thereafter, will that include implementing or successor legislation in the UK? It's not clear if the contract doesn't say. And this lack of clarity is likely to be more pronounced in areas where the EU has significant regulatory measures, so some financial services contracts, or for instance, where parties have confirmed and warranted they will comply with EU rules on X. What is that still to be the case afterwards? I mean, I suppose if you're an English company and you've said we will comply with the EU regulations on X, even if the UK is no longer bound by those regulations, you've still warranted that you will. And I think the starting point would be you are intended to comply with them. But do you intend to, and do you want to still be bound by them post the end of this year? So those sorts of issues need looking about. And again, for contracts, if you're doing these things now, I think it's worth perhaps including general provisions that deal with modifications to legislation, and just think about what you do want to apply going forward. Agency, I just mentioned, it's not a sort of dispute resolution per se, but it's an area where you do get a lot of disputes. So I don't think Brexit should have too much impact on commercial agency regulations, at least straight away. A lot of the principles are derived from English common law in any event, rather than EU legislation. There is the relevant EU directive, which is enacted here by the Commercial Agents Council Directive Regulations 1993, which do give commercial agents increased protection through some rights which exceed rights at common law. Under the withdrawal agreement, the UK has agreed those regulations will remain in force after Brexit, though on a different constitutional basis, not because it's an EU law that we're bound to apply, but because we've chosen to apply it. Once the immediate aftermath has gone, that might be an area where the UK government sees benefit in diverging somewhat, depending on the nature of our other arrangements with the EU. And if we're free to, that might be an area where a slightly less regulated sector is deemed desirable. But who knows? But if you're an agent for someone and you're concerned about the possibility of losing these sorts of rights, it would be worthwhile negotiating to enshrine them in your contract and to set them out explicitly so that you agree them contractually and not have them imposed by law or have that uncertainty as to whether they will still apply. And my final quick point, what about Brexit? Can that be a ground for termination of the contract? I mean, clearly it might, when we finally crash out or limp out or leave on whatever basis we finally leave, even if we're still tied to the EU for good or ill, clearly that could have a big effect on the profitability of a lot of contracts. So, and all sorts of things like fluctuations in exchange rates, tariffs, customs checks, effect on the labour market, these could make some contracts really unprofitable. The starting point, I fear, will be you generally can't rely on Brexit as a ground to terminate those sorts of contracts unless it's already written in that you can, because the English courts start on the basis that we're going to hold parties to their bargain, even if it's a bad bargain. And there are only sort of limited exceptions to that. If there's a force majeure clause that applies, or the contract has been frustrated. Financial hardship on its own, lack of profitability, is very unlikely to mean that a contract's been frustrated. We've advised a lot of clients of that point in the context actually of the pandemic, when they've been, the profitability of doing what they agreed to do suddenly becomes commercially nonsensical, but they can still do it. They just have to lose money when they do it. Similarly for Brexit, just because this horrible thing happens doesn't mean the contract is frustrated. And there was the Canary Wharf for the European Medicines Agency case, when the European Medicines Agency argued that its 25-year lease of premises in Canary Wharf was frustrated because of Brexit, and they had to re-site themselves in whichever country it was in the EU. Was it France? Can't remember. But the court said, no, that's not frustrated. You can still have this lease. You can still pay the rent. The fact that you don't want to be based there anymore is not a frustrating event. So I think Brexit is unlikely to help you get out of contracts. So that the key, and I suppose coming on to what should contract drafters or contract managers be doing now, the key is to review them, renegotiate where you can, achieve clarity on areas of ambiguity where you can. And I guess if you do have regular dealings with EU countries, cross your fingers that we are going to agree some sensible regime, such as letting us into the Lugano Convention, to make your life a bit easier should those contracts go wrong in the future. So yeah, there's a lot more to it, and sort of law and jurisdiction issues are complicated enough anyway. So this extra layer of uncertainty put on the top as a result of the Brexit process is, well, good news for dispute resolution lawyers, I suppose. But I shouldn't cheer that. I should deplore it, because clearly we would much rather have certainty for all your sakes. Anyway, there you are, dispute resolution.
Thank you, Simon. Now, I'm conscious of time, so what I will do is try and rattle through the questions by grouping them. So there's been a question which I think is probably a question to me: will there be any Brexit effect on Inco terms? So the answer in the context of the Inco terms themselves is no. The Inco terms are set by the International Chamber of Commerce, and the latest version is 2020. So Brexit itself doesn't change the Inco terms. However, what you need to do is consider the Inco terms that you are trading on and decide whether they are still appropriate in the context of changed border arrangements between the UK and the EU. Because, for example, Inco terms dictate who completes customs formalities, who makes tariff payments, and so on. And so you can see that an Inco term that you chose that was viewed as fairly sort of vanilla and innocuous, actually in the context of the end of the Brexit transition period, could have a very different implication for your business. So the answer is the Inco terms don't change, but actually the practicalities mean you need to revisit the Inco term you typically trade on. I think what we'll do next is go to the data protection questions, Peter, if you don't mind. So the first question is, can you confirm that the SCCs, the standard contractual clauses, are the same as the EU model clauses? So are they one and the same? And if they're not,
yeah, no, they're the same thing, just different people referring to them in different ways. So as it happens, I think I used to call them model contracts more often. These days we seem to call them SCCs, but it's the same thing. Okay,
thank you. Right, another one, Peter. GDPR, how to update policies that refer to the EU GDPR and associated articles. Is the UK GDPR going to be a new statute or incorporated into the current DPA?
Effectively, it's the latter. So it's part, but it is right to say that references, if they're not broad enough to refer to our Data Protection Act 2018 and the legislation that relates to it, then so sometimes we do see references that are purely to the GDPR itself, then they would need to be updated because our UK GDPR is going to be separate. So it is right that that's one to look at in terms of the drafting.
A couple of questions that I think I can roll into one here, Peter. So you commented on the transfers between the EU and UK post-transition. What about transfers between the UK and non-EU? For example, the US, will standard contractual clauses still be needed? And somebody else asked a similar question about whether the SCCs are available on the ICO side and can they be used for data transfer from the UK to the US?
So yeah, there's sort of a couple of points there. One is it only to the extent that it's talking about EU individuals, to which the answer is no. Effectively, we are inheriting a very similar law, so we will have the equivalent restrictions on transfers out from the UK of data in the UK. And the answer is, I mentioned Schrems earlier. Some of you may have been to previous talks on this, but post Schrems, we don't have privacy shield, so standard contractual clauses is sort of all we've got for transfers to the US. They're not ideal, and the current guidance puts a lot of onus on people relying on them to make sure that applicable laws at the destination country are not going to get in the way of the privacy of the people whose data is being transferred, which you might say, where does that leave us when we know that the US laws post-Schrems judgment are arguably too intrusive to protect individuals. So I think the answer is what we're seeing most people doing is put in place audit trail to make sure they've thought about it, look at technical measures to protect things, but carry on transferring. I have heard some people say, I'm not sure that if you read the letter of the guidance that transfers to the US are possible, full stop. But what obviously things would grind to a halt if that were the case. So my experience has been people do use those SCCs for US transfers, but with some a bit more of an audit trail about the basis on which they're doing it.
Thank you, Peter. I think in the interest of time, Mark, let's pick up on a couple of the immigration questions. So the first one that came in was, are students who are currently studying able to work during study?
Yes, so previously we have had a restriction on the amount of work that student visa holders can actually undertake. And although the visa route for students has been updated, it has changed. The requirements in terms of work are the same. So what that actually amounts to is if an individual is in the UK studying on a student visa, they can work, but they can only do so part-time up to 20 hours per week.
Okay, thank you. An interesting question here. Should we avoid asking about status to work during the application stage to avoid potential discrimination?
Yeah, so I mean, this is a difficult area, obviously, because there is interplay between, of course, discrimination law, but also the requirements to meet right to work checks. The advice really is, look, this shouldn't be an issue that should be coming out through the initial periods of the recruitment process. So, you know, within your adverts and things like that, you certainly shouldn't be specifying that a particular visa is required, because obviously that would be discriminatory. In practical terms, once you get further through the recruitment process, the reality is those issues will come to light anyway. And if sponsorship is required, that's the sort of thing that can be addressed with an applicant much further down the line, perhaps once we're at the shortlist or final interview stage. Because of course it would be in their interest as well as yours if sponsorship is required, for everyone to be aware of that ahead of time.
There's a question here, Mark, around timing. If I don't need to hire Europeans until Q4 2021 earliest, how long would it take to apply for a sponsor license?
Yeah, so
until next summer.
Yeah, absolutely. I mean, obviously, the recommendation is to get this done as soon as possible. But the reality is, if there isn't a business need, the sponsor license application process itself is likely to take anywhere between 1 and 2 months. And that's including the preparation time for actually getting the application submitted. Strictly speaking, the Home Office can take up to 8 weeks to make their decision, but in practice, that doesn't happen. It's much closer to 4 or 5 weeks. So you can definitely look at starting next summer and still have a license ready in time. Obviously, I would say a bit of a caveat: we don't know how many applications will be being submitted over the course of the next 12 months. So things may slow down a little, but in practice, I don't think that changes the advice really.
Okay. Question here, Mark. Is it the 30th of June 2021 for current resident EU nationals to have applied or received confirmation of settled status?
To apply. That's
okay.
My mistake. I should have clarified. It's a deadline for an application. In practice, a determination is likely to come through straight away, but if it doesn't, that's not a problem. They must apply.
Okay. One final one here. In terms of working in the EU, will business visas be sufficient for UK staff performing services for clients in the EU?
Very difficult for me to say. This isn't a satisfactory answer, but the reality is that each EU state will be in charge of that themselves. And so although we are likely to see some sort of standardized system, particularly across the Schengen area, in practice, it's going to have to be a case-by-case decision based on the country that the individual is actually going to and the nature of the work, because some work would be permitted for visitors, most wouldn't.
Thank you, Mark. Now, I'm mindful of time, so I would suggest we draw this morning to a close. If any of you have asked questions that you don't feel we've answered, feel free to contact one of the speakers directly. Like I say, the webinar recording and the slides will be circulated in the early part of next week. As we close the webinar, a feedback request will come up, and like I say, we really appreciate your feedback and you spending just a minute completing that for us. So thank you very much for joining us. Hope you found this interesting and informative, and we look forward to seeing you soon. Take care. Bye bye now.